So yesterday we had already discussed that this is a case of abuse of process of court. Charges have already been framed. Everything was discussed about father's quashing being dismissed. So, sir, today I would like to start with, sir, in the Supreme Court in the case of Amit Kapoor versus Ramesh Chandra reported in 212 9 SEC 460 has held us under
2012?
9 SEC 460. So this is the study referred to this court in my father's quashing application. This lays down the situations where the court can invoke the inherent powers under 482. So, sir, paragraph 27, having discussed the scope of jurisdiction under these two provisions, that is section 397 and section 482 of the code, fine line of jurisdictional distinction. Now it will be appropriate for us to enlist the principles with reference to which the court should exercise such jurisdiction. Sir, paragraph 27.1, the power of quashing criminal proceedings, particularly the charge framed in terms of section 228 of the code, should be exercised very sparingly and with circumspection, and that too in the rarest of the rare cases. Sir, point 27.6, the court has the duty to balance the freedom of the person and the right of the complainant or prosecution to investigate and prosecute the offender. 27.7, the process of the court cannot be permitted to use for an oblique or ultimate or ulterior purpose. 27.8, where the allegations made as they appear from the record and documents annexed therewith to predominantly give rise and constitute a civil wrong with no element of criminality and does not satisfy the basic ingredients of a criminal offense, the court may be justified in quashing the charge. Even in such cases, the court would not embark upon a critical analysis of this evidence. And this is last point is 27.15 on this page. Coupled with any or all of the above.
29.
Yes.
Coupled with any or all of the above, where the court finds that it would amount to abuse of process of the court or interest of justice favors, otherwise it may quash the charge. So, sir, with that being said, I would like to argue, sir, on the civil aspect of this case, 27.8, and I would like to refer the Honorable Apex Court finding, which I just gave to sir, the respondent as well as to the court. So this is sir, Criminal Appeal 4003/2024, arousing out of FL3. So for this, I would direct this court to page number 4. Paragraph 7.1.
Yes.
The learned senior counsels for the appellants have contended that the allegations in the FIR are general and omnibus in nature and lack material particulars, bereft of any details, rendering the complaint vague and obscure. There is an existing civil dispute between the father and the son, and as such, the FIR is an abuse of process of criminal law. Further, section 161 statements of the witnesses are identical and are based on information from respondent number 2. They are vague and do not have any material particulars about the date and time of the incident. Sir, paragraph 8, analysis.
Yes.
After identifying certain allegations in the complaint FIR, the High Court came to a quick conclusion that there are specific allegations against each of the accused. After referring to certain precedents on the scope and ambit of the power under section 482 CRPC,
Yes.
the High Court came to a conclusion that exercise of power under section 482 for quashing an FIR and complaint is not warranted
Yes.
in the facts and circumstances of the case. Beyond holding that there are specific allegations, there is no other analysis. The duty of the court, High Court, where it... Yes, sir.
We just give the sanction. We will discuss your case now.
Yes, sir.
Last settled. So you need not to. What point you have argued?
Yes, sir.
Just right.
Okay, sir. I'll come to paragraph 9.3 on page number 9 of this study only. Sir, of this study only, page number 9, paragraph 9.3.
ये जजमेंट को रिलाय कर रहे हैं जो अभी दिए
सर मैं फैक्ट्स पे भी आऊंगा सर, फैक्ट्स पे भी आऊंगा.
Now you come to the, you have already argued.
Yes, sir.
Your submissions are there. What I have noted.
Yes, sir.
These are the submissions because
सर एग्जैक्ट सपोर्ट कर रहा है सुप्रीम कोर्ट के
evidence of process of law.
Yes.
You argue.
Yes, sir.
No evidence collected during investigation.
Yes, sir.
And
सर ये सिविल नेचर का भी है सर, जो चार्जेस 420 और 406 हैं।
This is another point.
यस सर, इसको क्रिमिनल नेचर दिया गया है और उसी के सपोर्ट में सर मैं फाइंडिंग्स दे रहा हूँ।
Yes.
तो सर पैराग्राफ 9.3 अगेन सर फाइंडिंग पे है, पेज नंबर 9। The duty of the court when FIR has predominating and overwhelming civil favor is also reflected in the opinion of this court in Jaswant Singh versus State of Punjab. This court observed that from the above discussion on the settled legal principles, it is clear from the facts of the present case that there was a clear abuse of process of court, and further the court had duty to secure ends of justice. We say so for the following reasons. So point A, the allegations made in the FIR had an overwhelmingly and predominantly a civil flavor, in as much as the complainant alleged that he had paid money to Gurmeet Singh, the main accused, to get the employment for his son abroad. If Gurmeet Singh failed the complainant, the complainant could have filed a suit for recovery of the amount paid.
That lie, we know.
Yes, sir.
Because prominently it is a civil nature.
Yes, sir.
Then certainly we can invoke the jurisdiction.
Yes, sir.
So you argue whatever facts you want.
Yes, sir.
So I is concerned that court will look into that law.
Okay, sir. Yeah.
You give the just citation and then.
Sir, I'm relating it to my case. So let me come to the allegation. So, sir, yesterday I discussed that her aunt, so the complainant had alleged that I cheated her of $30,000 in the name of preparing a visa, and then
Argued that it was already transferred
yes, sir.
to the auntie. That
Yes, sir. The aunt. So, sir, that is
of the complaint.
yes, sir. They instituted a case under 420, sir, criminal procedure. They did not invoke any civil procedure. They had the option of, if I had transferred if I had taken the money and duped them, they could have taken any, sir, remedial measures, civil suit. But instead, they filed a criminal complaint against me. So, sir, that is the point I'm trying to make it out. They had the option, but they did not. Sir, also, sir, this entire complaint has only 3 witnesses: the complainant, complainant's father, and mother. The complainant's aunt had not made any complaint to the Indian police. So, the complainant's aunt is a resident of USA. It's already alleged in the FIR, and she did not make any complaints. She could have also perused, sir, the criminal cases in USA also, because this money was transferred from a US bank account to a US bank account.
Yes.
So, sir, that shows that this is an abuse of process of the court. So, the court is justified in invoking its power.
Yes. Yes, Mr. Mehta.
Sir, now, sir, there are also allegations that. Do you want to say something?
No. You argue that this is a fit case to invoke the jurisdiction.
Yes, sir.
So points you have already canvassed.
Yes, sir. Yes, sir.
Because we can't continue to hear for hours together. Yesterday also we heard you about 1 hour. So you have to now something.
Yes, sir. So the court, while dismissing my father's petition, in paragraph 27,
Yes.
they said, sir, so this is one allegation that I've already discussed. There was another. The property of Sridhar or the respondent was refused to be returned and was sold by them for the personal gains. So this court considered that this allegation is very specific. So, sir, for that I would like to again revert back to the Supreme Court finding, sir. Page number 9, paragraph 10.
Kailash.
Yes, Kailash pen. Yes, sir. Same finding.
Yes.
Paragraph number 10. We will now examine the specific allegations in the FIR complaint. Firstly, the complainant referred to certain items which are said to have been given by her father at the time of marriage. These items are 1 Scorpio car, TV, fridge, DVD, tape, silver utensils, 5 lakhs. This allegation relates to the year 2002 and the present complaint is of the year 2013. So, sir, in my case also, sir, the allegation was like at the time of the marriage, 2017, but the FIR was registered in 2022. Now, sir, coming back to paragraph 10.1, the tendency to make general, vague and omnibus allegation is noticed by this court in many decisions. In Usha Chakrabarti versus State of West Bengal,
Mr. All ultimately it has to be seen in the light of the facts of a case.
yes, sir.
Large Sabha is concerned, we are not saying that the 482 cannot be invoked. Question is that it depends on the facts of a case whether
Yes,
it is
sir.
a fit case for invoking or not. Because law is also that it has to be invoked very sparingly and very sparingly.
Yes, sir, it is there, and that is what I am arguing
We
for.
will try to look into the facts you have and also the material which you have already argued.
Yes, sir. मैं FIR से इनकी एलिगेशन रीड कर लेता हूँ.
Yes.
सर जो इनकी स्टीवन से रिलेटेड एलिगेशन है वो मैं FIR से रीड कर लेता हूँ सर, पेज 30.
Yesterday you raised the FIR.
सर तो इसमें
From the FIR you pointed out that the allegation of misappropriation or the transfer of 30,000,
यस सर.
that is wrong because you had already retransferred it.
यस सर, अब मैं स्टीवन वाली एलिगेशंस पे आ रहा हूँ सर.
So this you have already argued. This is not appeal, Mr. Rastogi. That
हाँ.
try to understand.
अपील नहीं सर, मैं अपने लिए इंडिपेंडेंटली अपील कर रहा हूँ.
This is not appeal we are hearing. We are in a 482 petition. So you have to concise your argument that you have already argued that prima facie the allegations.
हमने बस वे यस इसमें सर किसी भी एलिगेशन में कोई वो डेट्स मेंशन नहीं है. इन्होंने 406 की एलिगेशन लगाई कि मैंने सीजन रिटर्न नहीं किए. इसमें देयर इज एब्सोल्युटली नो एलिगेशन दैट व्हेन शी हैड आस्क्ड फॉर दिस एंड व्हेन आई हैड रिफ्यूज्ड,
Yes.
or when they were given to me, how much it was given to me, whether it was given to me or to my father or to my relatives. This entire contents of the FIR, a bare perusal of the FIR shows that these very essential ingredients are missing. So again, sir, this is a good case for quashing.
Yes.
Complete over.
Yes, Mr. Matter.
May I submit something?
Yes.
All the merits allegations have been considered by this honorable court.
Yes.
In the earlier petition filed by the father of the present petitioner,
Yes.
that is the father-in-law of the complainant, in the para 6 onwards. And in para 27 of that order itself, this honorable court has come to a conclusion. May I read para 27?
Yes, that is on the angular.
Yeah. Therefore, if the facts of the present case are examined, there is a specific allegation of demand of dowry by the petitioner along with his son and also demand of money to provide the assistance of the financial support of respondent parties. And other allegation, I am reading last, but
बीच वाला भी पढ़ लीजिए.
sixth line from the bottom. The property of the Stridhan of respondent number 2 was refused to be returned and was sold by them in their personal gain. The respondent number 2 was being harassed by her husband and family member. Thus, prima facie, the ingredients of the alleged offence are existing. The legal position in relation to questionment of FIR is no longer restricted. If the allegations made in FIR or the complaint, even if they are taken into their face of it, face value and accepted in their entirety, do not prima facie constitute an offence or make out a case against the accused. The allegation contained in FIR is examined in the light of para 102 of the Bhajanlal case. Therefore, this court has taken all the factual detail minutely when the allegations of the earlier petitioner was taken into consideration. And in para 2, line 2 of para 27,
Yes.
the categorical observations are there. On the evil of the aforesaid law, if the facts of the present case are examined, there is a specific allegation of demand of dowry by the petitioner of that petitioner along with his son.
Yes.
Son means the present petitioner.
Yes.
And also demand of money to provide assistance. So this order has attained finality. He has not challenged this order before any other court. Therefore, my submission would be there is no illegality in this order and the order has to follow in the present case also.
Yes, Mr.
And another ground is the other allegation sections are also there. Section 3 and 4 of the Dowry Prohibition Act is also in that. Not only 406 and Act. Therefore, my submission would be 482 petition deserves to be dismissed.
Yes.
Here my humble submission. There is a written application by complainant 2222, my lord. And immediate after my lord, I convert to FIR, my lord. And उनके जो स्टेटमेंट हुए हैं वो 3/2/2022 को हुए. My lord, my humble submission. This petition before the lordship, my lord, is under section 482, my lord.
Yes.
मतलब 482 का स्कोप बहुत लिमिटेड है, मतलब माय हम्बल सबमिशन, क्योंकि इसको मतलब इज राइटली पॉइंटेड आउट, मतलब कि इसको अपीलेट, इसके जो कंटेंट है उसको अपीलेट की स्टेज की तरह कंसिडर नहीं किया सकते। मतलब ये पिटिशन तभी मेंटेनेबल हो सकती है तब प्राइमा फेसी नो केस मेड आउट अगेंस्ट मतलब एप्लीकेंट में। सो मतलब माय हम्बल सबमिशन की जो एलिगेशन आए हैं, बार बार आर्ग्यूमेंट हो रहा है कि ओमनीबस एलिगेशन है सर, रिटर्न कंप्लेंट है या एफआईआर के जो है कंटेंट है सर, इसमें ओमनीबस नहीं है, स्पेसिफिक एलिगेशन है। और सर उसकी पुष्टि के लिए केवल एलिगेशन नहीं है, उसकी पुष्टि के लिए स्टेटमेंट है। स्टेटमेंट के अलावा सर इसमें जो जब्ती पंचनामा सीजे बनाए हैं, उसमें कंप्लेनेंट ने जो जब्त कराया सर, उसमें 1 से लेके 135 तक के दस्तावेज विद फोटो है सर। तो जो भी एलिगेशन इनके द्वारा अपने एफआईआर में लगाए गए हैं, उसकी पुष्टि में डॉक्यूमेंट भी है। और उन डॉक्यूमेंट में इनके द्वारा जो एलिगेशन लगाए गए कि किस तरह पैसे को डिमांड की गई है और किस प्रकार के फोटो है, उसको सेल, जो ऑर्नामेंट उसको सेल करने के लिए जो इनने किए हैं, वो सारे हैं इसके अंदर। तो मैं हम्बल सबमिशन की ये पिटीशन इस स्टेज पे इनके खिलाफ प्राइमा फेसी पर्याप्त एविडेंस उपलब्ध है, इस कारण से ये इस स्टेज पे मेंटेनेबल नहीं है। और सर एमसीआरसी जिसका लर्नड ने कि उसमें सर इसी स्तर पे आप इसी कारण से मेंटेनेबल नहीं है कि इनसे एलिगेशन वाले की डिस्मिस हो चुकी, तो इनकी तो हो ही सकती। सो मैडम,
Yes, I will pass.
Sir, is the application allowed or?
No, that I will consider.
सर पूछ सर सर इसमें सर सुप्रीम कोर्ट ने डेफिनेशन ऑलरेडी दी हुई है कि सर एलिगेशन स्पेसिफिक क्या होती है।
Right now, I pronounce petition is dismissed.
सर
Detailed order will follow.
सर इन्होंने कोई एविडेंस से पॉइंट किया ही नहीं है सर, जो कहने एलिगेशन सर मटेरियल नहीं है ना उसमें।
Once the same FIR against your father was challenged in 482, petition has been dismissed. Allegations have been considered right or wrong. Yesterday also I said, how do you overcome of my judgment when you have this petition? That's why when you said you want right now, I pronounce that petition is dismissed, detailed order will follow.
सर 482 में पावर्स हैं सर, there is no restriction. Sir, there is no restriction
I
and
can't take a different view when I have already examined the same FIR, same allegation, and also I observed that
सर एपिकल कोर्ट की फाइंडिंग्स हैं कि ये
there may be a wrong
एलिगेशन नहीं हो सकती।
that order is, I can't take a different view when I have considered the same material, the same FIR. I have, how do you wanted, I pronounce that judgment.
I hope.
But